I am an attorney who works and lives in Richmond, California. And since 1990, I have formed cooperatives, dissolved cooperatives, represented cooperatives in litigation, and written about cooperatives. First article I wrote is this one right here for the Business Law Practitioner. And it's a joint publication of the University of California and the California State Bar. You may notice the consultant was Robert Estes, who at the time was the chief accountant for Deloitte Touche for their cooperative divisions, which include its accounts such as Land of Lakes and Ocean Spray. So cooperatives is not just small business, it can be large concerns as well. And I will be speaking about much of the subject matter. Much of the subject matter I will be speaking about is covered in this article. This article also has the code references that I'll be talking about, both in terms of state and federal code. The objective of this workshop is to examine the reasons why to join a cooperative in the first place, in comparison with your other entity choices, what operational advantages that provides, and how you can create a different business culture. All those things I think are important. Personally, I believe that workers' cooperatives, and my focus for the most part is going to be workers' cooperatives. Okay. My focus for the most part is going to be workers' cooperatives. And I believe that this is an underused legal asset. I believe that it provides a great deal of operational advantages that have not been used. I know through my own experience at the University of San Francisco Law School, it was never mentioned. I don't think it's mentioned in any other course curricula. I don't think it's ever presented or often presented as one of the choices people can make. But as you'll see when I get later down into things, it's one of 4 choices that are available. Unfortunately, it's not mentioned, and I think the time is right. The decision whether or not people join workers' cooperative really begins at birth. Because if you're not born into wealth and influence, then you have to figure out how you're going to make a living. And your first basic choice is whether you work for yourself or you work for someone else. Now, working for someone else recently is less attractive. That's called employment. And it's really been quite a bit less attractive. It's less stable. Work is less certain. There's too much competition at the bottom. Workers have far less leverage than they used to have in the marketplace. And union representation has gone down. When I was in my youth, I used to work, was a member of several unions, and they had power. They made a difference in the workplace. Right now, they're just a figure leaf. They don't exist. So you have to make that first choice, whether you're going to work for yourself or work for someone else. And given what the employment situation is, working for someone else is less attractive. Now, if you're going to work for yourself, then you have another choice to make. And that is, do you work for yourself alone, or do you work for someone else? Now, if you work alone, there's a lot of limitations. There's only so many hours in a day. There's only so many tasks you could perform. It limits the type of work that you can do. It limits your outreach in terms of clientele. Certain businesses, you know, you can work effectively as a sole proprietor, but such as an attorney or a dentist. But I think once you're involved in the actual making of something or providing a service, it becomes very difficult to become a sole proprietor. The other problem with being a sole proprietor, of course, is that you have personal liability. So right now I'm defending a contractor who unfortunately never was incorporated, who is being sued on a wage and hour claim, and he has to face the music personally because he was never incorporated. So this could go directly to his personal assets. Now, if you work with others, as I say, you have to make choices. If you don't make certain choices, the legal system will make them for you, and you probably won't like it. Because if people are working together, whether they call themselves a partnership or not, they're going to be treated as a partnership. And that includes unincorporated associations. So if a cooperative is presently an unincorporated association for liability purposes, it's a partnership. And what does that mean? That means that each person who is a member if it's seen as a partnership, can be personally liable. What is called joint and several liability. In other words, someone who has a claim against the unassociated corporation could go against any individual or any number of the individuals or all of them together to satisfy the claim. They could name any of these people. You could just pick one person if they wanted. So again, what you're doing is you're providing yourself liability exposure if you do not incorporate yourself. Or maybe I should backtrack. It's not a matter of incorporation, but you register yourself with one of the state-recognized entities. And that's where that's where cooperatives come in. Because if you do take some type of governmental action, in other words, you do some type of state filing, which would be with the Secretary of State's office, you really have four choices. The first choice is a stock corporation, and that's what most people are familiar with. And in a stock corporation, you purchase stock, and your voting rights and your economic rights are dependent upon the amount of stock that you own. So if you have 60% of the stock, you get 60% of the vote. And you also get 60% of the dividends. Same thing with a partnership. Now, we'll get into that in a second, but it's the same type of economic and political rights. They're based upon your paid-in capital. Now, there's a subspecies of a stock corporation that you may be familiar with. It's called an S corporation. An S corporation is the same thing as a regular corporation. It follows the same state corporate rules. The only difference is that it gets a different tax treatment. And an S corporation is usually limited to smaller companies, both in terms of the number of shareholders and the amount of business that it's doing. All large companies, such as publicly traded companies, are what's known as C companies. And when I use the word C or S, these are references to IRS code sections. So a C corporation, then you have an S corporation, and we also have a T corporation. The other type of entity is called a limited liability corporation. And I'm sure many people of you heard it called LLCs for short. And what a limited liability corporation is essentially a partnership, but with the liability protection of a corporation. One of the advantages, of course, of being a corporation is that your personal assets are not subject to any suit by the corporation. You're protected, unlike a partner or a sole practitioner. So a limited liability is a way that you can operate a business as a partnership. In fact, it's a very loose way. You don't even have to have a management structure. You can appoint a single manager, and that person could have all discretion. So it's a very loosey-goosey way of operating a business. And for people who, for people who are looking for simplicity, or where simplicity is demanded in the operation of a business, this may be the way to go. It is a popular business form these days. Another entity is called a limited partnership. And a limited partnership is another form of a partnership in which you have a general partner, which often could be in the form of a corporate entity to save it from liability exposure, which usually holds a minority position, maybe 1 or 2% of the interest of the partnership, and the rest is held by silent partners, people who don't really want to be involved, they just want investment. And this type of entity is suitable for, let's say, a real estate development where the participants are not really interested in anything more than getting money back. They're not interested in running the business. So they're willing to sit back, take a silent position, and just receive the benefits as being a partner, but with the protection, again, the liability protection that comes with other protected entities. And the fourth type is a cooperative. And a cooperative, in most situations, is or should be a corporation. It's a subspecies. Now, cooperatives are broken down into two major categories. You have the marketing and consumer cooperatives, which I combine together for the simple purpose is that their financial and economic objective is to lower cost. So people, for instance, in a consumer cooperative, want to buy food as cheap as possible. They pool their resources in order to do that. People in a marketing cooperative want to lower their cost of doing business, which is marketing. So you have individual producers who form a cooperative in order to market their products. Worker cooperatives are unique in the sense is that they are both produced and marketed by the members themselves. That is the income-producing entity. Whereas in a marketing cooperative, the income-producing entity are really the individual farmers. They're just using the marketing cooperative to sell their products and to get a good price. By the way, I should have mentioned this before. If anyone has any questions, bring them up as I speak, because then the subject matter will be pertinent, and then I could possibly go into a deeper analysis, or may bring up issues I didn't think about. So if you have any questions, be free field to ask.
What was it? What's a T Corp?
A T corporation. And I will get in that in a second, but a T corporation is the tax code which applies to cooperatives. And when I speak about patronage dividends, which is controlled, well, I will be speaking several times about SubChapter T, which is very important. So yeah, you have the, so if you were to look at the tax code, you have the three types of corporations. The C corporations, a regular corporation, an S corporation, which does not have any corporate tax liability so long as you comply with the requirements, and a T corporation, which I'll speak about later, which allows you to do some very interesting things with your taxes. Okay. Now the differences, there are three, let me step back on something. I'm sorry, I'm getting a little ahead of myself. While you have these different entity types, that doesn't mean that you're stuck. One entity, for instance, a number of cooperatives can form a limited partnership. It doesn't mean that you cannot, that one entity cannot join another entity in another entity status. So people are, for instance, the example that I gave you with a limited partnership. Most often, general partners in limited partnerships are another form of corporation. I personally believe, and this kind of picking up on something I said at the beginning, that there really is a historical time for cooperative development. I think the last 30 years have showed us that triple down doesn't work, that we can't build an economy based upon over-leveraged assets when we're not producing anything and not creating any real wealth. I think that we have to make jobs instead of find jobs because of the employment situation, among other things. I believe also that the Bay Area has demonstrated through several of its cooperatives that it is a viable and a very good way to do business. We have businesses now that have been in existence for 30 and 40 years, which have shown consistently not only the ability to operate well, but to provide their members benefits greater than comparable entities. And I remember when I was writing an article, this is 1992, during the first Bush recession, I was interviewing, I believe it was Missing Link, and they were actually expanding their business at the time of a recession. So what this showed to me was a lot of economic strength if cooperatives are organized well. In other words, not only can they do well in bad economic times, they can do well in good economic times as well. I think there's also conditions favor the development of cooperative. I think given the type of economic times that we have, I think people are more willing to invest their time than their money. In fact, I think that's where they're going to be going. People don't have money, they do have time. And they would like to be able to turn that into sweat equity. And that, in many ways, can be a replacement for paid-in capital. I think more and more jobs will be based upon intellectual property instead of large capital investments. And again, that favors cooperatives, for reasons I'll explain later. And I believe that people are finally get it that you don't need to build a business by investing a whole lot of money. You can do it not on a shoestring, but you can do it with some smart spending. To use a consumer analogy, instead of buying an expensive sound set, go to Craigslist, buy an amplifier and a couple speakers, and you're in business. And I think in many ways people are going to have to follow those type of guerrilla economic tactics and build things from the ground up with whatever they have. And given the economy now, who knows, there may be a lot of things that could be purchased for cheap that could help you start a business. So for instance, if someone's involved in a food creation business, you may be lucky. You may be able to find freezers, you may be able to find places available in which you're not going to be able to make a large capital outlay. Now, the differences between cooperatives and other types of entities, I think, are best expressed in SubChapter T, in the code sections and the regulations. And the reason so is that in order to get the treatment under SubChapter T, you have to operate as a cooperative. And the codes and the regs have defined what that is. There was a case which I cite in this article. It's in fact one of the first cases I cite, and I cite it often, is the Puget Sound case. It's one of the only cases I'm going to tell you by name. Thanks. And the case is 44 Tax Code 305. It was decided in 1965, and the issue before the tax court was whether or not workers' co-ops qualified for the cooperative treatments, whether or not they operated as cooperatives, like farming cooperatives and other type of cooperatives. And it's a very interesting case because what it did is it reviewed the origin of SubChapter T. This was part of John Kennedy's most progressive legislation. It's kind of forgotten in terms of his legacy. But this was the tax structure that he created shortly before he was assassinated. It was 1963. And the Puget Sound case, which is still used by the IRS for identifying who is operating as a cooperative and who is not, set forth 3 operational characteristics which make cooperatives different. One is the subordination of capital. The second is democratic control. And the third is distribution of profits by means of patronage dividends, or distribution on a patronage basis. Okay. Yeah, sure. Subordination of capital, democratic control, and patronage dividends. And I will be speaking about each of these to greater length. Otherwise, you know, if you do not look at these 3 characteristics, a co-op corporation is just like any other corporation. You have the same limited liability protection. You have the same management structure. You have the same formation and dissolution procedures. And you have the same ability to transfer your stake in the company. It's a little bit different, though, with a cooperative. Now, go on in. That's okay. By the way, are there any questions up to this point? Okay. Subordination of capital means that the benefits and the control is not determined by contributed capital. That is a huge revolutionary concept in the way that one does business. In a normal corporation or in a normal partnership, as I mentioned before, your economic and political rights are based upon what you paid in. That's it. In cooperatives, capital does not control. What this means is that you get paid or you receive benefits for what you do instead of what you own. So what it means is that that property no longer has the intrinsic value, i.e. the entity. It is a platform by which you personally can create a profit for yourself through the cooperative structure. And it's all based upon your individual participation, not based upon what assets or what stock or interest you hold in the company. The benefits stay and remain with the members themselves. Where is a cooperative, given this distinction, where is a cooperative, or what type of businesses are most appropriate for a cooperative business? Why is that awfully loud? They're businesses where, yeah, stop right down. They're businesses where, for the most part, their development is based upon either sweat equity or development of intellectual property, or they're able to share the initial risk between them. It is not appropriate where there is a large capital investment, because in that situation, which most people do, is basically putting down their money and taking a risk, and they're entitled to that. But there's a huge issue of relevancy when a capital investment is not the driving force behind a business. And this, again, is where I think cooperatives have huge advantages. Let's suppose we have a business, and I'm going to use it for simplicity's sake, that two guys come together, or three guys, and they want to put together a t-shirt business. They invest $6,000, exactly. But through their combined efforts and their ingenuity and what they're able to do afterwards, they're able to grow that business to a $6 million business 2 years later. Now, why should the amount of money that they contribute, which is a mere fraction of the business that they're doing at the present time, continue to control their business, their economic and political interest? I think it's a distortion, and I think what it does is that it does not it rewards inertia. It does not reward participation, ingenuity, all the things that make a business go beyond just investing capital. So again, you have to choose. A cooperative is not a magic wand. It does not fit every situation, and it's not the appropriate choice for every situation. But given, I think, where businesses are going, where people are going to have to build them from the ground up, in other words, there's going to be businesses are going to be less dependent upon a large capital investment, and their success will be more a result of their subsequent efforts and development, then I think a cooperative in those situations may be the best choice. I think it would be the most, if nothing else, it provides the most equitable rewards of benefits. It also keeps people honest. And I'll give you kind of a analogy. I've never worked in a large law firm, but I've talked to people who have. And one of the big complaints is that you would have senior partners who would do nothing but basically get their cut. And it really created a lot of resentment among those people who were doing the work and making the money for the firm. So I think this is a way to rectify this, because what happens is that the benefits are geared upon production, or as we call it in the cooperative language, patronage. Now there's a downside to this as well. The downside is that you can't raise capital from the outside, because you're not providing an investment. I mean, I know that there is going to be a talk about ways of financing corporations as one of the next lectures, and I'm not going to go into that issue. But the possibilities of raising capital from outside sources are fairly limited, I believe. So I think that the sources for a startup corporation are really twofold. They're either internally or there's some form of debt. And one of the solutions that I've been trying to propose in the city of Richmond, where I live, and anywhere else one wants to listen to, is a revolving fund in which it would provide startup cooperatives with seed money upon presentation of a business plan, and the obligations would be fully secured. These are not gifts. They would be secured by whatever assets the corporation had. They would be required back to pay back the loans. Of course, you would have to put together a payout schedule that could work with the cooperative. It's not going to bleed it to death. And the business plan would have to show how it would have to be able to service the debt load. That money would go back into the fund and would provide capital for other cooperatives. So I think one of the Achilles' heels in cooperatives is that ability to find startup capital. I've been involved, and so has Casper, with some people who were talking about putting together a credit union, but under the rules and regulations for credit unions, very little, if any, of that money can be used for startup. So it's really not an effective financial institution. Debt, I think workers' cooperatives, I think, should be making greater demands upon the national cooperative banks and other institutions, other cooperative financial institutions, that at least in terms of their mission is to provide funding to cooperatives. And I think it all can be in conjunction. It doesn't have to be from one source. So startup capital can come from a number of sources. In fact, I think if anyone who is seeking a loan, if they can show that they're putting in their own money, they would probably have a better chance of getting it. A question may arise in a situation where someone wants to form a cooperative, but they have an individual asset. In other words, maybe they have a facility where you can do certain production, or maybe they have intellectual property in terms of a copyright or a patent. Now, is that going to be an ambition to form a cooperative? Not necessarily. Because what you can do is you can create an arm's length transaction in which you can license that asset, sell that asset, lease the asset, so long as there is a full disclosure to the board of directors of the cooperatives. So what you'll be doing is simply you'll separate that asset from yourself. And this is one of the times I'm going to cite to a code. The California Cooperative Code section 12373 provides some of the procedures that need to be followed in order to do that.
I have a question.
Sure.
You mentioned board of directors. How many members is it required by the tax code, or I know corporations?
I believe it's a minimum of 3.
For corporation purposes only, or for the duration of the actual existence of the cooperative?
No, I think you have to have a minimum of well, it depends, because a cooperative can actually be formed by 1 member. So I think once you go beyond 3, it has to be at least 3. And yes, you have to have a functioning board during the existence of the cooperative. Any other questions? Okay. Democratic control means 1 person, 1 vote, regardless of your paid contributions. And think of the opposite situation in the stock corporation. You could have 1 person who really has virtual control. You could have 10 stockholders, but 1 person has 51%. That person can control the corporation. You can't have that in a co-op. You can't have any type of concentration of control like you have in other types of entities. To quote a tax case, all members are able to exercise a franchise of equal strength. Why is that good? Well, as I mentioned, 1 is you don't have minority control. It also avoids a hostile takeover. You can't have someone from the outside and try to take over the business just by the ability to purchase shares. It also could prevent. Well, this may go into. No, I'm not going to go into this because it deals with a different subject. It also means that each person has a meaningful vote, that no one is disenfranchised. And it means, because the members themselves are the only ones for voting, it's that their interests are front and center. And I think one of the problems you have with investors is that their interests could be at odds with the people who are running the business. They may be looking for a short-term return, or maybe that's all they're looking for. Whereas people running for the business are more interested in the business environment itself, or planning on a long-term basis, especially in a cooperative, because they're investing in themselves. And I presume that people expect that they'll be around for a while, so their interests are necessarily long-term. Sure.
The worker buy-in that cooperatives use when a new owner comes on, is that a form of...
I'm sorry, what do you mean?
Worker buy-in, like when a new owner comes on and they pay into the company a certain amount, and then when they leave and they get that amount back.
Oh, okay. Are you talking about membership, your initial membership?
Right.
Okay.
So is that mean like capital startup?
It can be, and I'll go into that in a second. Yeah, but just to remind, that could be your first entry in an internal capital account. It could be. Maybe I'll get back to that, but let me just address that question. One of the things that a cooperative has the option of doing with their membership fees is they can decide how they're going to use that. And they can apportion a certain amount of that money as an asset to the cooperative, and it stays with the cooperative. It there becomes a cooperative asset. Or it could allow a certain portion or all of the money to be redeemed to the members once they leave the cooperative. And that's one of the issues. I'm getting a little ahead of myself, but that's one of the things you want to address in the bylaws. Now, one of the reasons why it's important to have this control, the political control of a cooperative, is because it allows people in the cooperative to determine their own workplace environment. And to me, that's a hugely important issue. While I'm well aware of the need of a business to be economically solvent, and economic objectives certainly have to be front and center, and if they're not, you're not running a business. It doesn't have to be the only objective. And I think many people engage themselves in cooperatives, involve themselves in cooperatives for a number of reasons. They don't have anything to do with economics. They may want to use certain products, they may want to maintain a certain ecology, they may want to create a certain business culture. And they're these all things that are separate from the actual clinking of change that may go into their pocket. And by having this control, it allows you to do this. Worker members are able to create their own environment. It doesn't mean that they will, but they have the tools to do it. Now, I, for one, and I've stated this in this article, am a little bit critical of the one person, one rule vote. I believe that people who have a greater participatory role should have a greater voice. However, I don't believe that that greater voice should be the difference between those who have the most votes and the least votes should never be to an extent that it would disenfranchise any cooperative member. So I've suggested a 3-to-1 spread. That is, the top member gets 3 times the amount of votes as the bottom member. It doesn't have to be 3-to-1, but that's the, yes, go ahead.
And that would still keep a cooperative within the SubChapter T?
Oh yeah, it wouldn't affect. Wait, no. Let me go back. No, it would not. Under both the state and the federal rules, it still has to be one person, one vote. So there would have to be change in the laws themselves. Yes. So I'm saying this is, I'm making a criticism from a legal point of view, but the law is the law, and both state and federal law require one person, one vote.
So just to be clear, in a cooperative, there is no such thing as what you just described.
Right, there is not. It's just my criticism of the existing standard. There is, I think, what you call a central organization where there's several cooperatives together, then they can do what's called cumulative voting. Right, you can do cumulative voting, which is somewhat like that. It's not exactly one person, one vote, but it does not apply to individual members in a cooperative. Also keep in mind, and this is also to disabuse anyone, a cooperative is more demanding than any other forms of business because you're doing double duty. And you should do them both well. One is your job, and the other is running a company. So it's really kind of a two-edged sword because it allows workers to participate and receive the benefits of the fruits of their labor. It also puts the responsibility for them to make the business work. They can't blame it on the man. They're the man.
Or woman.
Right? You got it. And that brings me to the issue of corporate governance. And my advice is do it. Do it for a number of reasons. What I mean by corporate governance, that means have your membership and board meetings, have those meetings, have minutes of those meetings, provide information at those meetings so people can make meaningful decisions, keep people a track of what's going in the cooperative in terms of its revenue production, potential contracts, equipment once a purchase. It's a good way of keeping tabs on things. I can tell you, as a person who's litigated for more than 20 years, bad business decisions, many of them occur when people let the business slip, when they just let things happen. And believe me, things will happen. Another good reason for doing that is for what's called alter ego liability. That if you're just running a corporation and it's just a phony baloney, I mean, it's not really acting as a corporation. It's not electing officers, it's not conducting meetings, it's not doing anything that a corporation should do. Then if you're exposed in a liability situation, one of the options that a party can do is say, you know what, you're not protected by the corporation, it's not real, I'm going after you personally. Now it's a heavy evidentiary burden, but believe me, if you let things go, it can be easily proved that you're not doing it, because cooperatives are required to maintain certain records, and if you don't have them, that's pretty good evidence that you're not conducting yourself as a cooperative. In small cooperatives, I would recommend that all the members are officers and directors. And I think this is, number one, a way to share responsibility. By small cooperatives, I say up to 10. So in terms of your officers, you have your required officers, which is your chief executive officer, your chief financial officer, and a secretary. And then I would appoint vice presidents. And not just vice presidents in the ambiguous sense, but vice presidents with defined responsibilities. And that gets everybody working for the cooperative and providing information. And it also allows you to diversify the responsibility. It's not just on the board, but you have all these other people providing the various components of information that are needed to make decisions. Another good reason for doing this is that it could be a basis providing an exemption for workers' compensation. And under Labor Code Section 3351, if all of the members or shareholders are also officers and directors, then they are only subject to workers' compensation if they so choose. I think as a practical matter, if you get beyond 10 people, workers' comp may be asking you some questions, unless, of course, you can show that there is some real legitimacy in all the other vice presidents that you've appointed. But, yes, go ahead.
So how many VPs?
Probably 7.
Is the max?
Well, I don't think there's any hard and fast rule, but I think at some point it loses credibility. In other words, so long as each VP is fulfilling a function, and a function that is needed by the cooperative. So maybe one VP is involved in marketing, one VP is involved in purchasing supplies, one VP is involved in an outreach with other companies. It could be a variety of issues and a variety of functions. So long as they're legitimate and serve the cooperative interest, I think that you can make an argument that they're needed and that becomes viable. Go ahead.
Just before you get off of workers' comp,
Sure.
So I wasn't aware that owners would be covered by workers' comp. I always thought that was something that
Under this exception, in this exception.
If it's less than 10 people.
No, it's not if it's less than people. If all the owners are also, in other words, let's put it this way, the only members are the officers and directors of the company.
Okay.
So, all the members have to be officers and directors. And my point is that it starts to lose credibility after 10.
Correct me if I'm wrong, but he was actually suggesting that small cooperatives.
Yeah.
Yeah. For larger cooperatives, I think you need to decide what decisions will be made by the board and what will be decided by members. Some of those decisions could be issues such as new membership, contracts, asset purchases, among many. Now, the existence of a cooperative begins with the filings of the Articles of Incorporation. And there's several forms available which can give you examples in terms of what to say and what not to say. Code section 12310 states the required provisions, and I can just tell you out of personal experience, say exactly what's stated word for word. I had a finding that came back because I started a sentence with the word this instead of the. And unfortunately, given the lack of resources in the Secretary of State's office, things take a very long time, so you don't want to be involved in time-consuming procedures. Another important issue, another thing that you want to state in your articles of incorporation is your pre-existing agreement to provide patronage distributions, and that individuals will account for those distributions in their personal income tax. If you are converting an entity to a cooperative, then you want to file what's called restated articles of incorporation. And I'll get to those a little bit later on. But whatever articles you find, your articles of incorporations for the cooperative that you do put together and are signed by the requisite corporate officers, they should be filed, I believe, in person. The reason I'm saying this is that the Secretary of State, again, is just not functioning. I'm waiting now 6 months for restated articles to be approved. So if you send them in my mail, I sent them in by UPS service, the same thing as mail, I guess, for them. If you send them in for mail, it could take forever. If you walk them in, it should take probably less than a couple of weeks. And unfortunately, they used to have an office in San Francisco, but now you have to go to the office in Sacramento. But I believe it's worth the drive. It'll save the time. The second filing that you have to make, state filing, is what's called a Statement of Domestic Stock Corporation. And this is done within 90 days after your articles have been filed. And what this essentially is a one-page form which lists the officers and your agent for service. Do not use the nonprofit domestic stock corporation form. That is strictly for mutual benefit and public benefit nonprofit entities. Much of this information, by the way, in the forms can be obtained at the California Secretary of State's website. The internal documents you need to put together, your first internal document are the bylaws. Now, the code gives you the option whether or not you are to have bylaws. I think you're foolish if you don't, because I think you're just asking for trouble, and you're just going to be running an organization in the seat of your pants, and chaos will most likely be the result. The required and optional provisions are stated in Corporate Code Section 12330 and 12331. However, I think there's many other additional provisions that should be considered. And this is one of the reasons I think that people should hire their services as a professional or an attorney, because it's not just a matter of what is the law, but it is thinking out the process in terms of what type of provisions best suit the type of entity that you want to create. What is tailored to your objectives and your concerns. And often you have to talk those out and think those out until you really come to a conclusion. But some of the issues that I think that should be addressed are the grounds upon which members can be expelled and the procedure for doing this. And this actually comes from a personal experience when I was involved with a cooperative in which we had a very disruptive officer, but there was no stated grounds in the bylaws in which he could be expelled. And his conduct did not comply with the statutory grounds for expulsion. So again, I think it's important that these issues are defined ahead of time, that people know what type of conduct is expected, what will be tolerated, what will not be tolerated, and what will be the procedure if people get out of line. There should be provisions for redemptions for unpaid capital for anyone who leaves the cooperative. And this, again, is very important. A person may be expelled, a person may leave voluntarily. What do you do with the money that's still retained in their name? And this maybe goes to the membership provisions that you were talking about. I would recommend something in the bylaw which would essentially state that the person would receive the benefits that they would if they had remained in the cooperative. So for instance, if there was certain money that had been retained in the cooperative and there was a 3-year payout for that money, they would get that money in 3 years. They would not jump ahead of the line in front of other people just because their membership was terminated. Again, I would also repeat the pre-existing obligation to make patronage dividends that can be stated in the articles, and the definition of patronage dividends, how they will be maintained, and the type of accounts that the cooperative will keep. And the individual retained money can be kept in what's called internal capital accounts, just like in a partnership. And you can have undivided corporate accounts, as I said, which are corporate assets. And the patronage of the cooperative is free to decide to whatever extent it wants to make those distributions to individuals or retain them within the cooperative itself. It can make that adjustment. It also should discuss, the bylaws should discuss issues about transfers of membership, redemption of membership, how many directors, whether there should be a supermajority, whether officers and directors should be indemnified, what should be the record date of voting, and different classes of stock. And that goes to the issue of certain financial arrangements, because I know there has been discussion about preferred stock, and if there is preferred stock, you want to create a different class because you don't want to give the preferred stock the voting rights that only apply to the members themselves.
So, excuse me, you can have stock and have voting issues that are totally separate.
Right, you could have non-voting stock. So what you would do is you would create a second class of stock. Now, I'm not totally hung on the idea of stock. I think it's somewhat superficial in a cooperative. I think membership is fine because it doesn't have any intrinsic value. It's just kind of a paid-in deposit which you receive some or all of when you leave. It doesn't go up and down with the fortunes of... but for purposes of maintaining a balance sheet and showing that you're not too heavily into debt and you do have assets to support the cooperative, for that purpose and that purpose alone, it may not be a bad idea to have your initial payment called stock, and then your other contributions can simply be membership contributions. The bylaws, by the way, are enforceable in law. You can go to court. If there are non-discretionary provisions in bylaws that have not been complied with, for instance, if there's supposed to be a distribution at a certain time in a certain manner, and it's not done, you can go to court. If elections are supposed to take place at a certain time and they haven't, you can go to court. So long as it involves a non-discretionary act. Go ahead.
Who would take you to court on that? Would that be like a disgruntled?
Exactly. Remember, anyone who has standing. So that would be anyone who's a member of the cooperative. So any member who feels, for instance, there's election, it's supposed to happen, they haven't happened, that member can go to court and get an order compelling the election.
Does the bylaw need to be filed with the state?
No, it's never filed. It's an internal document. The only documents that are filed with the state are the articles of incorporation, the domestic stock corporation. No, it's a domestic operation.
But when you go,
You-
go to court, the judge would ask for a copy of
Well, of course, you would.
So it's filed eventually if you get in trouble in a sense.
Well, it would be filed as part of a court action, of course. It would be filed as part of a court action, but it's not a filing with the Secretary of State. It has nothing to do with your official status of being a corporation. You can still be a corporation or a cooperative without having bylaws. I just think it's a bad idea.
Besides being named as directors and the initial buy-ins, which I'm assuming all cooperatives do, but I don't know.
What's that?
Initial buy-ins
Yes.
for each owner.
Yes.
Is there any other paperwork that proves that each person is a member?
Yes, I was going to get to that. Good point. That's a good, and that's called a membership agreement. And a membership agreement could cover a number of things. Number one, it can say It could have a member's declaration that they accept the bylaws. So it puts them on record for saying that they're bound by the bylaws. It could also state workplace policies. It could state work requirements. And here's the big one, as far as I'm concerned. It should also give notice to all members of the cooperative who are working of the availability of their right to take breaks and the availability to take breaks within certain portions of the cooperative. The reason I'm saying that, I have a case right now where I'm representing a pumping contractor who had a number of individuals who would act on their own at the job site and pump concrete. They're their own boss. This one guy was fired after 15 years of work, and he says, by the way, I never got breaks. I'm suing you for $200,000. So one way, when I'm talking to you about my litigation experience and how it comes to use, is to use it as a form of preventative medicine. So this is a form of preventative medicine. You put the person on notice that breaks are available, they're aware of that fact, and they're aware that the cooperative has made certain accommodations, and whether they take breaks or not, that's their business. But they will not be in a situation, or you will not be in a situation, where someone can game the system, and don't think it can happen in cooperatives, because I also represented a cooperative about 2 years ago in which 2 of its board of directors sued the cooperatives for meal breaks and rest breaks, even though they were the duty officers at the time when they were working. Incredible. And given the way that the labor laws are, where everything is stacked up in their favor, in terms of burden of proof, in terms of attorney's fees, in terms of the basic assumptions, they had to be paid off. It was a shakedown, but they had to be paid off. So this is a way to prevent this. And I can tell you from my experience with many labor law issues, it can be real nightmares if you don't handle them right.
Can I ask a question?
Sure.
Back to, this is what you were talking about a little while ago about membership meetings, and I was just wondering about how that's reviewed and like enforced by, I guess, the state or.
It's not. See, what happens, you're raising a very interesting question. Because how does the state become involved, and how do some of these actions come about? There's no such thing as a corporate police. You know, there's no one going from corporation to corporation seeing if you're doing the right thing. What happens is some disgruntled employee gets pissed off and they go running to some agency. And that's, in my cases in workers' comp or EDD, almost invariably that's what happens. So it's not triggered so much by any policing effort, but it usually happens when there's some type of disruption within the workplace, and someone wants to use this either as a remedy or as a stick to bang the cooperative.
So I'm a little unclear why labor laws need to be mentioned in the membership agreement. If the law is there, do we have to list all the laws?
No.
I mean, so how do you know which ones you actually are needing to put into a membership agreement if they're already on the books?
Well, I wouldn't mention labor laws per se. What I would mention is that you would have a statement in the membership agreement in which what states that the member has been informed that the cooperative has a policy that all people who work there are to take designated breaks per the requirements of the labor code. You don't have to mention what they are. And that it has a place it designates a place where they can take these breaks. So the members have been put on notice that they have these rights, and then the ball is then in their court, whether they do it or not. But if you don't do that, then you're opening yourself up for a claim for someone says, hey, I was never able to take breaks, or they never provided the ability to take breaks. And again, the employee's burden is pretty minimal. The employer gets hit by one of these suits is really in deep doo-doo. So it's something you want to prevent before it happens.
Okay, but other than breaks, let's say
meal breaks.
Other than breaks for meals and rest and that are required, what if it's a construction company and there's all the OSHA guidelines? should you have a policy in there saying that the members are aware of all the OSHA?
You may. What you may.
How far do you go with these kind of things?
Well, it's individualized. It depends how far you need to go. If you're in a construction industry in which workplace safety requirements are an issue, and people have been provided with OSHA manuals, you may want to state that. They acknowledge that they have received either the OSHA manual or the cooperative's policy in terms of workplace safety.
Can these agreements be updated?
Of course, of
And
course.
If something that you feel is necessary, you just update it.
Right.
And make sure that it's distributed among the members.
Exactly, exactly. Okay. Any other questions? Okay. Okay, there's also, I mentioned this briefly before, there's also ways in which existing entities become cooperatives. An unincorporated association files articles under Corporation Code 12301. They follow the provisions of that, and they could become a cooperative, or a regular corporation become a cooperative by filing restated articles of incorporation subject pursuant to Corporate Section 911. Patronage dividends is the third distinguishing characteristic. And this is a good point to talk about the whole concept of whether a cooperative is a profit or a nonprofit entity. It's profit, it's not nonprofit. And it's specifically allowed to operate as a profit-making corporation under the California Corporate Code. Section 12320 says a cooperative can carry on business at a profit. Now, here's an intriguing section. The beginning of the California Consumer Cooperative Code states, excuse me, cooperatives are organized to make a profit for themselves as such, or for their members as such, but primarily for their members as patrons. In other words, people cannot make a profit on the work of anyone else, either individually or the corporation. People are essentially making a profit on the basis of their own patronage, which provides kind of a very unique situation, because on one hand, a cooperative must act collectively in order to produce the income, but is distributed on a flow-through basis somewhat similar to a partnership. So it's kind of a hybrid organization. In some ways, it has the best of both worlds. I think personally that in the marketplace, cooperatives should do very well, because they have certain built-in advantages. If you don't have to award an investor class, that means you have more money available to be price competitive and to provide more money to the members. So I think the marketplace is great. I think another problem with going on the nonprofit route is that if you have any economic objectives other than to provide a pure service, it's a bad choice, because you're going to accumulate assets one way or another, either in the forms of earnings or in the forms of accumulated assets, and they cannot be distributed. If you're a nonprofit, all you can do is give those to another nonprofit. It also, the whole concept of patronage dividends awards a participatory investment. And this is again a distinction between other types of entities. A member of a cooperative theoretically could gain as much, if not more, than someone who is a member of a cooperative than someone who is receiving a higher salary. Let me explain. In a stock corporation, a person who has 30% of the stock is never going to receive more money than someone who has 50% of the stock. But in a cooperative, a person who earns less than someone else possibly can gain more in terms of the patronage dividends. For example, for the sake of simplicity, let me give you an example. Supposing we have an outfit which has an engineer and we have a draftsperson. The engineer makes $100 an hour. The draftsperson makes $50 an hour. The engineer's salary is twice that of the draftsperson. But if the engineer only works 1 hour and the draftsperson works 4 hours, the draftsperson's actual contribution is twice that of the engineer, and he or she gets to take the appropriate amount of profit, actually gets to have more profit than the person who's making the higher salary. So you cannot, this is again a distinguishing characteristic. Never, in a corporate scenario, will someone who owns less stock be able to receive more money than someone who owns more.